I'm Joel Chandler. Welcome to another episode of Unsealed. In this limited podcast series, I take you behind the scenes for an unfiltered look at various open government projects that I've worked on in the past, projects that I'm currently working on, or projects that are still in the planning stage. We also discuss various issues that intersect with open government in Florida. Before we begin, I'm not an attorney. I am not qualified, nor am I authorized to give members of the public legal advice, so I don't. What I'm sharing in this episode is based on my own experiences working on open government issues here in Florida since 2008. Today's topic is Section 119.12 of the Florida Statutes, and in particular, the notice requirement that was added in 2017. These notice rules shape how lawsuits over public records unfold, and both requesters and agencies need to understand them clearly. Here's the statute in a nutshell. Section 119.12 says that if a court finds an agency unlawfully refused to provide access to public records, then the court must award the requester their reasonable costs of enforcement, including attorney's fees. But there's a condition. Before filing a lawsuit, the requester has to provide written notice identifying the public records request and then wait at least 5 business days. That condition has raised a lot of questions. For example, does the original public records request count as that written notice? Many people assumed that if the request was made in writing, that satisfied the requirement. The 4th District Court of Appeals squarely addressed this in Roldan versus City of Hallandale Beach in 2023. In Roldan, the requester argued exactly that his original written request should serve as the statutory notice. The court disagreed. It explained that the statute sets up 2 separate steps. First, the request itself, and second, a distinct written notice identifying that request. If the legislature had meant for the request to double as notice, the notice requirement would have no purpose. The court affirmed dismissal of the case for lack of proper notice. So the first lesson is clear. Even if your public records request is made in writing, it does not substitute for the written notice required by Section 119.12. If you intend to enforce your rights in court, you need to send a separate notice, keep proof of delivery, and allow the agency the 5 business days the statute requires. But there is an important exception built into the law. Section 119.12, paragraph 1, subsection B, says that this notice requirement does not apply if the agency has failed to prominently post the contact information for its custodian of public records. And that means 2 places: on the agency's website and in its primary administrative building. If the agency hasn't done both, the requester is not required to provide written notice before suing. This is significant because in practice, many agencies have not complied with the posting requirement. In fact, it is common to see websites with no clear custodian contact information and many buildings without a visible posting. That failure effectively waives the agency's right to the 5-day notice. For agencies, the solution is straightforward. Post the required custodian contact information in your main office and post it prominently on your website. A good practice would be to place it on the website's homepage right next to the notice required by Section 668.6076 regarding public records and email addresses. That way, members of the public can find it easily, and the agency can preserve the benefit of the notice requirement. For requesters, the takeaway is just as straightforward. If you want to be certain that you can enforce your request in court, provide a separate written notice that clearly identifies your request and retain proof that you delivered it at least 5 business days before filing suit. If the agency hasn't properly posted the custodian information, you may not need to provide notice at all, but it's still wise to document everything carefully. The point here is not to play games. The purpose of the notice requirement is to give agencies one final opportunity to provide records before litigation. The purpose of the posting requirement is to make sure the public knows who to contact. When both sides follow the law, disputes can often be avoided entirely. So to recap, Roldan versus City of Hallandale Beach confirms that the original request does not count as notice. A separate written notice is required. But if the agency hasn't prominently posted its custodian information in both its building and on its website, the notice requirement does not apply. I'm Joel Chandler. Thank you for listening to another episode of Unsealed. Remember, the truth dies in the dark.